Test. I'll just try to actually speak into it. How's that? All right, we are live on YouTube, and we can go on the record. We on the record, Connie? We on? Okay. Good afternoon, everyone. Welcome to case number 9708, Washington Gas Light Company's application for approval of a new gas system strategic infrastructure development and enhancement plan and accompanying cost recovery mechanism. Let's take appearances, starting with the company.
Good afternoon, Your Honor. Spencer Nichols on behalf of Washington Gas Light Company. I could also enter the appearances of my colleagues, John C. Dodge and Robert Kane, C-A-I-N.
Good afternoon, Your Honor. Can you hear?
Push the button.
No. Push. Good afternoon, Your Honor. I'm Sari Amiel on behalf of Sierra Club, and I'll enter the appearance of my colleague, Jory Jaffe. And I have our cards if it's easier for spelling. Of course.
OPC
Good afternoon, Your Honor. Ryan Hsu on behalf of OPC.
and staff.
Ruthie Herman on behalf of technical staff, and may I also enter the appearance of Michael Dean on behalf of the technical staff? Thank you.
Mr. Nichols, did you have an exhibit?
Yes, Your Honor. I have marked as WGL-1 a certificate of publication of notice of this pre-hearing conference that was filed this morning. I can certify that Washington Gas published notice of this hearing in the Maryland footprint of the Washington Post on July 13th and July 18th, 2023, as well as in the Frederick News Post on July 12th, 2023, and July 17th, 2023. The company also posted notice of this hearing on its website and through social media posts beginning on June 18th.
All reflected in what was filed as mail log 304218, correct?
Correct.
They'll be marked as WGL Exhibit 1. Any objections to it coming into the record?
No objections.
WGL will be admitted into the record. Okay. I did receive the petition to intervene from Sierra Club. I didn't see any other petitions to intervene. Mr. Nichols, did you?
That's correct. We expect AOBA to make an appearance, but they may not have gotten notice of this filing yet. So I have informed AOBA of this filing.
You have?
I have, yes.
And no objection to Sierra Club's petition to intervene, correct?
No objections.
Okay. Sierra Club's petition to intervene will be granted. I received your email this morning with competing suggestions. I have a few questions. We'll just take the companies to start with. Under your proposed schedule, who is filing testimony on Wednesday, September 6th?
That would be the company, as well as any cross interveners.
What's a cross intervene?
I don't know, Your Honor. It would be the company.
The company, and I suppose if either OPC or Sierra Club disagree with staff or each other, I suppose, Your Honor.
So it's really rebuttal of any and all parties, correct?
Yeah, rebuttal of direct, I believe, yeah.
That's correct.
And similarly, a couple lines down, you have rebuttal dash interveners. What does that mean?
That would be the interveners filing their, that would be rebuttal from any party, including the company.
So the word interveners is, I just crossed it out.
I think that's fair.
Any reason for 2 public hearings?
Only
They're
that's
virtual?
what's been done. That's what was done the last 2 cases.
That were in person, correct?
They both would have been in person, yes.
Okay. I think 1 virtual public hearing will be sufficient. What's wrong with September 12, 13, or 14? Anyone?
I'm sorry, for public hearings?
Yeah. My preference is not to have it on Monday, September 11th for a couple of reasons.
Right. Well, I guess first, Your Honor, OPC would like to suggest that we have a in-person hearing, primarily for the reason to provide the public any opportunity, particularly for those members of the public who may not have best access to internet. In terms of the dates,
But wait, stop with your first point.
Yeah,
Did you make
sorry.
the same request in case number 9704?
I am not certain, Your Honor. I'm not on that case.
I know the notice of procedural schedule in that case indicates that there'll be 2 virtual public hearings. Do you know, Mr. Nichols, whether anyone requested the hearings in the rate case to be held in person?
I know that nobody requested that they be in person, but they were set to be in person. Those haven't been scheduled yet, though, in the rate case.
Not according to the notice of procedure schedule.
The public hearing dates?
Order number 90653, issued on June 7th, the very last sentence.
That's in 9704, Your Honor?
Yes, it is.
Okay, thank you for that, Your Honor.
The last sentence says, after consultation with the other parties, Washington Gas Light Company is directed to contact the executive secretary to establish the dates and times of the virtual evening public comment
Okay, thank
hearings
you, Your
in
Honor,
this
for
matter.
that clarification. I apologize for my mistake.
That's okay. So, are you going to have them in person or virtual?
We're open to do either, Your Honor.
In that case.
In that case, yeah. But, I mean, if the order says virtual, we're going to go by with what the order says.
Now, do you have anything else to say about 9704? Are you,
Not
is
particular-
your
I'm not-
appearance entered in?
I'm not in. My
you're
appearance is not in. I don't.
Mr. Dean, can you come up to the table? Are you in 9704?
Yes, Your Honor.
And do you have anything to add to this discussion on comment hearings?
No, Your Honor. I noticed the virtual hearings, and I didn't have any comment on it.
That staff is amenable to the public hearings being virtual in 9704.
Yes.
And in this case?
We didn't take I didn't know of the question on whether it would be virtual or not coming up. Normally, it seems to be the practice since the pandemic to have virtual public hearings. At least for the comment hearings, yes.
Correct. I'm inclined, Mr. Shu, that since the commission has indicated, I'm assuming a preference for virtual evening public comment hearings in the rate case, that we should have a virtual public comment hearing in this case as well. Until I'm sort of told otherwise about a preference.
Yes, Your Honor, in addition, a person could also make written comments.
Of course. And the reason I said that I think only one virtual public comment hearing is necessary is because people can always go back and watch it, and they can listen to it and then write in comments at a later date, so as long as it's held early enough. So I think only one is necessary since it's virtual, and like I said, I don't like Monday, September 11th, so I would prefer 12th, 13th, or 14th. If anybody knows now that they have conflicts, please let me know.
I believe the 12th might be preferable. I believe Columbia, we may be having hearings on the 13th and 14th, depending on, that schedule hasn't been established yet, but I think the 12th would be preferable.
Yeah, I don't see anything on the calendar for the.
Yeah, that hearing hasn't, that's tomorrow, Your Honor. We were, I think we've agreed.
I'm going first.
Sorry.
So, right? Okay. So I think the 12th for that. And then my next question, why do we have 4 dates for evidentiary hearings?
Because that's what we had in the last case, Your Honor.
No, it's not.
Well, that's my understanding of what we.
Are you talking about the scheduling order or what actually happened?
In our last, I could be mistaken, Your Honor. My impression was that we had 4 dates for evidentiary hearings because that is what we had scheduled in the past 2 stride cases. But if that's incorrect, then I
You may have
apologize.
scheduled 4 dates, but in
Correct.
the last stride case, it went for 2 days, and the second day only half day.
Okay, that may be the case. I wasn't aware of how long they actually went.
So, does anyone think that we need 4 days? Does anyone think we need 3 days?
No.
I don't believe so, Your Honor.
So 2. 2 is a
believe-
lot easier to work
Yeah,
with
I
my
believe
calendar.
2 should probably
tell
be
you that much.
sufficient.
Okay.
That's fine.
So, if we can schedule 2 days, I think we can do September 25th and 26th.
Your Honor, I believe the 25th is a religious holiday, but we can double check on the calendar.
I believe it's Yom Kippur.
Yeah.
Okay, then we can't do that week because I'm out, 27th through 29th. We could do 26, 27, and then October 2.
That's fine.
Sorry, Your Honor, the 26th and the 27th?
Oh, no, not the 27th. I'm out the 27th.
Yeah.
We could do the 26th and then October 2nd. We'd be, dividing it up a little bit there. Not preferable, probably.
That would make the briefing a little difficult.
No, we're only going to have 1 brief. I don't want 2 briefs. We'll have one set of briefing due October 16.
Your Honor, OPC would like to have 2 briefs. I think we would strongly prefer to have the opportunity for a reply brief, respectfully, Your Honor.
Don't you think you'll appeal?
Perhaps.
You'll have lots of opportunities then, won't you, when you appeal my proposed order? I find reply briefs often to be repetitive, not helpful. And also, as you know, we have a compressed schedule because it didn't come up here, and it's up here. So I don't think we need that. I'd rather put the time somewhere else. Did you want to be heard?
No, we're good with that.
Your Honor, we had suggested the week of September 18th and 19th for the evidentiary hearings, but if you're saying it's going to be the 26th and 27th, I believe.
Well, you got surrebuttal. I had surrebuttal on September 19th, after rebuttal on September 8th. So I have direct August 28th per staff, I guess. Then rebuttal September 8th
September
And-
8th, Your Honor? Sorry.
for rebuttal, yeah.
Okay.
And that's again of all parties.
Mhm.
So then I get to serve rebuttal at September 19th, so I can't have a hearing before that. I think otherwise we're compressing the testimony schedule too tight. To go the week the company suggested for the hearing seems a little short.
I beg your pardon, Honor. What was the server rebuttal date?
September 19th. This all come out in a notice, but
Yeah, I would just note for the record, Your Honor, if I could, that the September 8th day for rebuttal is less time than we've had in our last 2 cases. We generally have had either 19 or 21 days, and that would be
from, what are you counting? I'm sorry.
for the time after the intervener initial testimony and OPC and staff initial testimony. We've generally had 21 days or 19 days for the last 2 cases, and that would only be approximately 10 days.
What did you propose in this case?
I proposed September 6th, as listed in our
That
proposal.
doesn't give you 21 days, though, right?
Well, I had that the intervener testimony would be due August 16th.
Okay. I don't think that's giving staff and innovators enough time. So when I
would
looked
just
at the 2 proposals, I thought staff was more reasonable in terms of time for testimony.
understood, Your Honor.
You look confused, Mr. Shu.
No?
Okay. So I can go over it again. I have direct testimony by OPC staff and any and all interveners by August 28. Rebuttal testimony by any and all parties by September 8. Public hearing on September 12. Rebuttal testimony on September 19. Evidentiary hearing on September 26 and October 2. We can start at 9 each day if people feel better about that, getting it in. We'll start at 9. One briefing due October 16. Target date for the proposed order will be November 3rd. And the proposed order will have a shortened appeal period. I went with, you guys actually agreed on those dates. Interestingly, you guys did not agree on the last date.
Oh, we can, Your Honor, we can defer that. It's December 13th is 180 days.
Okay. Do the parties have a need to go over discovery rules?
I don't believe so, Your Honor.
I believe the discovery rules from the prior case works.
Yeah, we've agreed
8 days
to 8
on
business days.
Yeah.
8 business days?
Yes.
Mhm.
Until when?
The day that it would be that Sir rebuttal is due, I believe.
So it doesn't get shorter?
Would be, so we've, in the past, what we've agreed to, we said 8 business days through the date of OPC and staff's initial testimony. So that would be August 28th. And then after August 28th, it would be 7 business days. Any objections within 2 business days?
The first objection period was 3, right?
Correct.
And then
After Sir rebuttal, September 19th, requests are due 3 business days, objections 2 business days.
electronic service?
Yes, sir.
All right, that'll be part of the notice. I'm not going to put project list or project decision deadline in. Those, don't those depend on what the order says?
It may, yes, Your Honor, I understand that. Yeah, our position is that without approved project lists by the end of this year, there will be some resources that are wasted beginning in 2024. So we're just, there's
Do
other
you want to
avenues.
expand upon that?
That we would have to, we wouldn't have a list of projects to work on starting January 1st if the project list isn't
Wouldn't the
approved.
surcharge end?
Pardon me?
Wouldn't the surcharge end?
Yes, Your Honor.
So how would money be wasted?
That's a fair point, Your Honor. We have crews that we would have to reallocate to other jurisdictions perhaps, and we would just not be doing work in Maryland.
You wouldn't be doing any work in Maryland.
I believe that's, well, if we didn't have a project list to work from for the Stride 3 period.
Do you want to think about what you just said? If your Stride plan is not approved, you won't be doing any work in Maryland?
Well, that's not, I didn't mean
I don't think
that.
that's what you
I meant through Stride.
Okay, anything else we need to discuss today?
Your Honor, I have a question. So in the petition to intervene, there's also a motion to appear pro hoc vice, and it seems that the Public Service Commission has the authority to enter an order that would admit myself not being barred in Maryland to appear without the presence of my co-counsel, Ms. Jaffe. So I was curious if...
Doesn't that usually go to circuit court?
Yeah, so I did file that motion in circuit court, but I wasn't sure if pursuant to Rule 19-217, it seems as if the commission might have the jurisdiction to enter the order, the waiver of a requirement of Ms. Jaffe's appearance.
What rule, 19 dash?
19-217D.
Whose rule?
I believe it's a commission rule, but I can double check on that. Maryland Rule 19-217. So is that's not a matter that Or is that a matter that the circuit court would be addressing?
Mr. Dean may be able to help me out. My familiarity is that the motion pro hoc goes to circuit court, they grant it, and then you're in. So I'm not really even sure what she's asking.
Normally, we wait for the circuit court.
Mhm.
I don't believe it's ever been done before, asking for a waiver of that.
Okay. Yeah, I applied in circuit court. I just wanted to ensure there wasn't a separate process by which I could waive the appearance of my co-counsel. But I think that that must be within the jurisdiction of the circuit court, which is fine.
Yeah, we have not, the commission has not addressed waivers before.
Okay.
It has been requested.
Okay.
I don't think it'll be an issue because the hearings won't be coming up until later.
Thanks. Okay.
Thank you, Mr. Dean.
Thank you.
Anything else?
No, Your Honor.
No, Your Honor.
Okay. Thank you, everyone. We're adjourned. We can go off the record.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, this is my name. Sorry, Amiel. Yes. Yes, of course. Thank you.